and welcome back to the OCO Roundtable podcast. From Oraro & Company Advocates, my name is Melanie Mwenda, and I'll be your host today. This is episode 2 of our ongoing series on intellectual property, where we unpack the legal tools that power creativity and protect what makes businesses unique. In the last episode, we unpacked the law around copyrights and how it safeguards creative works. We not only delved into the legalese, but we also looked into case examples, thus appreciating how the legal system has taken steps in ensuring that these expressions are safeguarded. Today, we shift our focus to trademarks. Whether you're bottling a soft drink, designing a luxury car, running a law firm, or styling hair out of a small studio, trademarks are what set you apart. They basically say, this is mine, and more importantly, this is not theirs. When you hear Coca-Cola or see the 3-pointed star on a Mercedes-Benz, you not only see a logo, but you also see a brand identity, a reputation, a legacy, and a promise of quality. In today's episode, we explore what qualifies as a trademark, the legal criteria it must meet, and how a simple slogan or a color can become one of your most valuable assets. Joining us in this conversation is John Mbaluto, Claire Mwangi, Wambui Mwariri, and Blenda Nyahoro, who are part of the firm's intellectual property practice group. Karibuni sana.
Asante.
Thank you, Melanie.
So Claire, you can start us off by unpacking what a trademark is.
In simple terms, Melanie, a mark can be defined as a sign capable of distinguishing the goods or services produced or provided by one business or enterprise from those of other businesses or enterprises. In other words, a mark enables a business to convey the message, this is my product or this is my service. And therefore, because of this, the owner of a trademark usually has an exclusive right to use the mark in the course of trade to the exclusion of all other persons. So that if I were to ask you today, Melanie, go buy for me a pair of shoes with a swoosh sign on them, or if I were to ask you, go buy a smartphone with an apple on it, or a fridge with a happy red face on it, I think you will quickly realize I am talking about Nike, an Apple iPhone, and LG respectively. Similarly, you would be able to differentiate Netflix from other online streaming services and DHL from competitor logistics companies. These are just but a few examples of a large range of goods and services that are instantly recognizable by a mark or even just a short slogan.
Okay, Claire, I hear what you're saying. So in light of this, can just any symbol or any color qualify as a trademark?
Yes, for as long as it is distinctive and not descriptive. So that's one of the characteristics of a trademark. So that while Apple is a very distinctive trademark for a computer based because it has absolutely nothing to do with computers, it will not be distinctive for actual apples. This is because someone who grows and sells apples cannot register the word apple as a trademark and protect it because his or her competitors have to be able to use the word to describe their own goods. Therefore, a trademark is not distinctive if it's descriptive. I could give you another example. There's this fencing material called sengenge ni ng'ombe. You see, trademark ng'ombe does not describe the sengenge, so then that's very distinctive. If you were to use ng'ombe, for example, or the real image of a cow for dairy products, it may be considered to lack distinctiveness. However, if the image of ng'ombe or of a cow is styled or combined with other verbal or figurative elements, the sign could be considered as distinctive. So that's the first characteristic. Then the second one, it should not be deceptive. A trademark is deceptive when it claims quality for goods and services it does not have. So that therefore you're producing bags and shoes that are made of pleather and you're calling them real leather. So then that cannot be a trademark because it's deceptive. And we have quite different styles of trademarks. And they come in different forms and styles. And I could give you just a few. For example, a word mark. This is the simplest type of mark and typically involves the name of the business in a certain typography. Examples of a word mark would include Vivo Fashion Group because Vivo is a clothing brand and Vivo is their trademark. Barbie, Art Cafe, it's the name of the restaurant and it's the name of their trademark. Disney, Google. However, we must say for Google, it runs the risk of becoming generic because it is so commonly used and has become synonymous with the word search. If this happens, Google will lose protection for this trademark. Because remember what we said, a trademark should not be descriptive. If I need to use the word Google to tell you, Melanie, go and Google this to mean go and search, then that cannot be a trademark. It will then fall into the public domain and they will lose that protection. That's a word mark. And then we have sound marks. For example, Netflix's Tudum is a sound mark. Nokia's ringtone, 20th Century Fox intro, all those drum rolls we had before we could start our movies, that's a sound mark. We also have service marks, and an example of this is like Visa. Letter marks, and this is a text-based mark that is used from an acronym of the word. For example, KCB for Kenya Commercial Bank. Brand mark, this is a symbol without any text, like how you move vehicles fuel into Shell without having the name Shell in Shell petrol stations. We have X, for example. We have Apple. There is no word. There is no name Apple. It's just a symbol of the apple. We have color marks. The blue color is a trademark, blue for Tiffany, which is a company that makes perfumes, jewelry, and accessories. Something interesting with color marks is that they have to be, for all these styles of marks we are saying, for example, in this instance, a color mark, you have to register that color. In the year 2018, we had Ali Hassan Joho, who was the then Mombasa governor, given an order for painting Mombasa blue and white. One of the companies known for its trade name, Best Lady Cosmetics, went to court and initially got an injunction because it has pink as its color. And one of its arguments was that coloring its building blue was infringing on its trademark color, pink. So it got an injunction at a preliminary point. But upon the substantive termination of the suit, because what it was saying is that it has used the pink color and it's synonymous with its trademark. And so this coloring was infringing and affecting its business. These businesses are spread across many towns in this country. And so it really wanted that order stopped. What the court did in its determination, in one of the major reasons why it lost this case, among many other reasons, the main one is, by the time Best Lady Cosmetics was going to court, the trademark protection for its trade name, Best Lady, had expired. Trademarks do expire. And so they had not renewed the trademark at the time. So because of that, then, that was one reason why it lost the protection for its trademark. As relates to its second argument, which being that they had trademarked the color pink, because they were saying that they have used this trademark for 15 years and it had become synonymous with its business as a means of identification by its customers. What the court found is that the registration of the trademark was only in respect of the name Best Lady Cosmetic Shop and not the pink color. And the court was very categorical, and it referred to Section 5 of the Trademarks Act when it said, no person shall be entitled to institute any proceedings to prevent or to recover damages for the infringement of unregistered trademark. Because of that, the pink color had not been registered, and so no protection. And so they lost. So then it could be painted blue, because then that was not its trademark.
That's very interesting. There's a few queries that I have there. So first of all, on the issue of deceptive marks not being open for registration of a trademark. As a young man growing up, I used to use a certain pen called Speedo. Now, I think the question that arises is the word Speedo seems to connote speed of some sort, but I don't think my writing was any faster.
John, I remember that. Well, first of all, I remember that when we were in primary school especially. I remember the teacher would be dictating notes and there's this guy who would write fast and then finish and then whisper, Speedo.
But I got no faster. I think I was even slower.
Well, yeah, it connotes that. I agree. That is arguable, John. That could be arguable.
Then on the Mombasa issue, this one I find for the called a best label. So what if it was actually a trademark that was in fact registered? And I come to think of, say, Jubilee Insurance that uses red, very dominant red. obviously, I don't think they went to court and therefore it becomes moot. But what if somebody who had an active trademark actually challenges? How then do you think the court would now grapple between the two interests? The interest of the county government as well as the Trademark Act, valid trademark. What would likely have happened?
Yeah, I think there would have been a cause of action in that regard. Because now the fact of unregistered trademarks then gave Best Lady no legal grounds to even start this argument. Yeah, that would have been arguable. Yeah. So, and what we're saying, given what the issue that John is just raising, whenever a trademark, if you see a circled R be after a trade name or a symbol after a trademark, it means that R, it's registered officially. However, if you see a TM after a name, a trademark, it means that's protection through use. Those are the Best Lady types who had not registered their pink color. Yeah. Then there are combination marks, and this uses a combination of a symbol and a text, but the text is not located within the symbol. An example is Oraro and Company Advocates, our trade name as a firm. We have the rising sun and we have our name. That's a combination mark. Another example is Lacoste, where we have the crocodile and the name Lacoste. Puma, we have the puma and the name Puma, as is the case for Airbnb as well. And lastly, we have emblem marks. And this involves both symbols and text, where the text is located within the symbol. An example for this could be Burger King. And these are just but a few examples because we have many more: texture mark, hologram mark, taste marks, there are many. But what we're saying is there is no limitation as to how you can want to trademark your business.
Thank you for shedding more light on that, Claire. Very interesting case there as well. Maybe just to shift gears, does then the mere usage of this symbol afford you trademark protection? Wambui, maybe you can take that up.
Thank you, Melanie. Like Claire pointed out, you must consider that even though you have rights through usage of your mark, the only true way to enforce your mark is through registration. So when you're considering registration, like all intellectual property rights, trademarks are territorial rights. So you have to consider where you're registering it, which basically means that if it's territorial, the protection is confined specifically to the territory where the registration is granted. This means that you have the option of going to each country separately for purposes of registration, or you can pursue international registration instead. Once a mark has been designed and selected, the next step is to decide whether or not you're going to seek that form of protection or simply rely on that protection through use. It is much easier to bring an infringement claim against the party infringing your rights when the mark is a registered trademark. So if you're considering local registration, it is done through an application at KIPI. KIPI is the Kenya Industrial Property Institute. To carry out an application for a trademark must be completed and submitted to KIPI along with the required documents and a fee. This application must provide a description of the mark, indicate which class the mark intends to be filed in, and provide a representation of the mark. However, before we reach that point, we strongly advise that you conduct a trademark search. This helps to determine whether anyone else has already registered or applied to register a similar or identical mark. While the search is not a legal requirement, it significantly reduces the risk of objections, opposition proceedings, or future infringement claims. A part of the application process that is extremely vital to pay attention to is the selection of the appropriate class or classes of goods and services. So what is a class? In simple terms, a class refers to a defined category of goods or services for which a trademark protection is sought. In Kenya, we apply the internationally recognized NIS classification system, which divides goods and services into 45 separate categories. For example, Class 3 covers cosmetics and cleaning products, Class 25 covers clothing and footwear, and Class 35 covers advertising and business consultancy services. A person applying to register a trademark must do so in respect of particular goods and services within one or more prescribed classes. In effect, this means that you're not registering your trademark generally. You're registering it for use in a specific commercial area, and your legal protection is limited to those classes alone. So, if you select the wrong class, the consequences could be significant. a registration under the incorrect class may not provide protection for your actual business activities. For example, if you're in the business of software development, but you register your mark under a class relating only to electronic hardware, the registration may not be enforceable against others using the mark in the software space. Moreover, an opponent could challenge and invalidate your registration purely on that basis. As at 2025, the average cost of registering a trademark in Kenya ranges between 10,000 to 15,000 per class in official government fees. When you factor in professional legal fees, the total cost per class typically ranges from 50,000 shillings to 150,000 shillings. Because these fees apply on a per class basis, the overall cost of registration will depend entirely on the number of classes in which you choose to register. Each additional class will attract further official fees. Once granted, a trademark registration in Kenya is valid for 10 years, and it may be renewed for further periods of 10 years each. This is provided for under Section 23 of the Trademarks Act. However, I would like to reiterate that the protection will only apply in the class in which the mark is actually registered. It is very critical to select your classes carefully from the outset, both to secure appropriate legal protection and to optimize the commercial value of your brand. When it comes to international registration, there's various systems you can opt for. So as opposed to going to each individual country to register your mark, you can also consider an international registration. And you can carry out an international registration through the World Intellectual Property Organization, which is WIPO. So this is done through the Madrid system for international registration of marks.
Yeah, Wambui, that's very interesting. But I wonder, is there any way through which somebody can enjoy protection under the Trademark Act without actual registration? So I've come across this concept known as well-known mark. So is it possible that, notwithstanding registration which you're detailing, that one can actually have this protection by virtue of being a well-known mark?
Thank you, John. That's actually a very good point. There are marks that can become well-known marks, and this is usually through the distinctiveness and the duration of use in which they've been in the public. And what you usually find is with marks like these, they have to be very widely identifiable. I can give you local examples that we can argue have earned a well-known status. Safaricom. As soon as you see the Safaricom mark, you know it's Safaricom. And anyone in a remote part of Kenya would be able to know it's Safaricom. So if you have such a mark, or you have, for instance, like Claire had mentioned, Google. Google has become so well known that then the word Google has ceased to just mean the identifier for this brand and has now become synonymous with search. I am going to Google this. So if you have a brand that has been used so much that you can provide evidence to support its recognition as a well-known mark, then you'd have protection under that provision.
And I guess Coca-Cola, as well as Melanie had indicated at the beginning, would also be a well-known mark?
Yes. I think of any mark that even if you went to the most remote areas, they'd be able to be like, oh yeah, I know that. So the reason we're able to do this from Kenya is that Kenya is a signatory of the Madrid Treaty and the Madrid Protocol. So an international registration under the Madrid system can designate various countries, provided that they're signatories as well to the Madrid system. So the end result of a registration under this Madrid system is that you get a bundle of national registrations. So it's both convenient and cost-effective, and it allows you to manage your trademarks worldwide. But you have to note that if you're going to file an international application under the Madrid system, you need to have already registered or have filed an application in your home IP office. So apart from national and global trademark registration systems, businesses also have the options to register in multiple African countries and other regional systems of registration. One such option is the African Regional Intellectual Property Organization. This one is commonly referred to as ARIPO. So ARIPO offers a centralized trademark registration system, but under the Banjul Protocol. This allows the applicant to find a single application that designates one or more of the protocol's member states. So it's important to note that although the trademark is examined and registered centrally by ARIPO, protection is granted only in the countries that the applicant selects and where the mark meets the national legal requirements. Kenya is currently not a member of the Banjul Protocol, so technically a RIPO would not apply. However, this system is useful if your business seeks coverage in countries like Zimbabwe, Uganda, Rwanda, and Botswana. Another regional system is the African Intellectual Property Organization, or OAPI. It provides for a unitary trademark registration, meaning that one single registration automatically covers all the member states without the need for separate national validation. You see, that's different from the case of the Madrid situation, because in this one, you are just doing one single registration and it covers all the countries. The ones I've discussed before, you have to actually select the specific countries in which that protection will apply.
So if Kenya Wambui was a member of the Banjul Charter, did you say?
The Banjul Protocol.
Banjul Protocol, a businessman in Kenya does not need to register first at KIPI.
Yes.
Because then they have that avenue where they can register there and also have protection in Kenya and other African countries.
Okay, so when we talked about the Banjul Protocol, that related specifically to ARIPO. But when you talk about OAPI, OAPI operates under the Bangui Agreement, which is separate. It's different. So for ARIPO it requires you to register and cover specifically the countries, the specific national registrations. However, if you register under OAPI is the one that allows you to file one single application, and that one registration will apply across all its member states.
I see.
Yes. So the current member states under the Bangui Agreement are primarily French-speaking countries in West and Central Africa. This includes Cameroon, Senegal, Ivory Coast, and Mali. Protection is automatic and uniform across all the member states. Kenya is not a member of OAPI, but businesses with operations or ambitions in Francophone Africa may find this route efficient and cost-effective.
So, Wambui, having had all these different avenues where we can register these trademarks, why, as a business, why should I care about actually registering the trademark?
That's a really good question, Melanie. Well, when you register a trademark, you get certain benefits from your trademark. One of them is recognition and brand loyalty. You see, over time, with consistent good experience with the product, it will translate to a brand preference. So this will help keep your business image alive in the mind of your consumers. If your consumers are happy with your products and services, they develop trust in your brand, and they become, over time, loyal consumers for all your products. So sometimes your satisfied customers may even develop an emotional attachment to your mark. Yeah, and employees could even be drawn to your employment at your company if you have a positive brand image. This will make hiring and employee retention so much easier. Another benefit that you'll get is the image of quality, because many consumers will buy a brand and not the product to which it relates. That means when a consumer comes across two otherwise identical products in the market, his choice will invariably move to the branded product. And it's specifically to the branded product of a business that promises higher quality. So that will help you enhance the brand's position in the relevant markets because of that perception of a higher quality. The business would also benefit from the image of having experience and being reliable. When the experience with a brand indicates that the brand owning it has consciously used its resources to implement a coherent business strategy, it reassures the consumer that that business is more likely to remain more reliable and trustworthy than others. Think of all the businesses that you know have been running for ages, all the businesses that talk about incorporated in 1930, and it's a brand that hasn't changed since then, and everyone now begins to associate it with that anchor in that space.
Like Bidco, for example?
Yes, Bidco is a good example, of course. Yeah, we can even use Coca-Cola as well in this situation because it's one of those companies that's very, very old and has become renowned because of that brand presence. So, Melanie, you see that not only is it important to register your trademark to prevent others from infringing on it, but there's so much value to be garnered from protecting your brand and from making it a solid part of whatever space you're operating business in.
You've definitely given our listeners a lot to think about. Thank you, Wambui. That brings an end to part 1 of this conversation. Stay tuned for part 2 of this conversation where John Mbaluto and Blenda Nyahoro we'll go further into discussing case studies and the conflict and concerns that arise in the use of trademarks and the internet. We value your feedback, and therefore, we encourage you to reach out to us on our social media channels using the hashtag OCO Roundtable. Until then, goodbye and take care.